Hi, my name is Monty Donohew, and I want to thank you very much for attending the Aging in Place workshop. We've got a lot to cover today, so I want to get right to the information. As you probably know from the information that was accompanied the invitation, I'm an attorney. I've been practicing for more than 30 years. My practice concentrates in the areas of estate planning and probate, trusts, and increasingly aging in place planning as a part and parcel of all of those other practice areas. I want to talk to you about what aging in place is, but I want to be real candid with you right up front. If you're attending this workshop thinking that we're going to provide you with information regarding how you can make your home more habitable and livable as you age, that is not what we're going to talk about today. So if that's what you're looking for, there are a lot of workshops that only deal with that particular issue. And I will be candid with you that that is a very important subject matter, and it is a very important part of your plan. But the reality is, if your home is habitable, as an example, and you are placed in a nursing home out of a hospital because your Medicare benefit runs out and you're not capable of making decisions because of your physical or cognitive ability, and you have no one able to make decisions for you because you don't have a proper estate plan in place, the fact that you have a home suitable for you is irrelevant. You're probably not getting out of the nursing home. Even if you're well, if you're not able to take care of yourself. If, for example, social services at a hospital or a nursing home says that you need 24-hour-a-day care or you need supervision for at least 8 hours a day, for example, and you have not put in place the possibility of making that happen, you're not leaving the nursing home. So while the home is an important and integral part of our planning, it clearly is not the only thing you should be concerning yourself with. And as a result, we're going to talk about all of the other things that so many of these workshops don't talk about. But again, I want to thank you for attending. This is actually the roadmap. What you're looking at on your screen is the roadmap of what we're going to talk about. It's the puzzle that we're going to solve, the puzzle of aging in place. So just by way of kind of rules of the road or some housekeeping issues, I am going to provide you with a workshop that I think is much different than other workshops or seminars that you've been to. For the most part, I'm not going to talk about me. I'm very proud of my background and my education, but I'm the least interesting part of this workshop, so I'm not going to spend any more time with that. In the email that we'll send you following your attendance at this workshop, I will include a copy of my biography. Of course, you can also find that on my website, and so I commend those to you. We're not going to talk about that anymore. This workshop is not intended to be entertaining. I'm not going to begin with a pithy story or humorous anecdote. This is intended to be educational and informative. As a result, instead of entertaining you, I'm going to apologize, because some of the information that you're going to hear today may sound scary. It may be disturbing. It may frighten you. That is not my intention, by the way. It is not my intention to frighten you or disturb you. My intention is only to inform you. I remind you that all of the information that is disturbing or frightening or scary are the result of individuals not planning their affairs and not having in place alternatives to the institutional care system. So what's frightening is to a great extent within your ability to plan to avoid. So remember that there is no certainty in any of the things that we're going to talk about today. As you can probably guess, I'm as a lawyer that what do you think the possibilities are you're going to get away without a disclaimer? Every presentation, every seminar, every article that you read, they all have disclaimers in them. And because I'm a lawyer, you're not going to get away without a disclaimer. However, I would like to even change that up. I think you would agree that most disclaimers you hear on the radio, on television, when you go see a workshop or a speaker at a seminar, the disclaimer is not for your benefit. It is for the benefit of the speaker. It is for the benefit of the person publishing the materials, broadcasting the information. The disclaimer is not for you. And you know that because sometimes they're spoken so rapidly, you can barely understand what they're saying. I'd like to make a disclaimer that is for your benefit. You see, you have a right to good legal advice. You have a right to good financial and insurance advice. You have a right to good health care and good health care insurance advice. The problem in our culture today is that so many people are so divorced from what good advice even looks like that they no longer recognize it when they see it. And they can't recognize things that aren't good advice because they haven't seen what good advice looks like. You see, in the legal setting, for example, in order for me to give you legal advice, I've got to know you. I've got to know what your circumstances are. I've got to know what your goals and objectives are. I've got to know what your needs are. I've got to be able to educate you regarding, to the extent that it's absolutely necessary and to the extent that it's reasonable, what you need to know in order to understand my planning and my advice, and also to answer any questions you have. In addition, if you're not able to answer questions, so often the quip that's made is that it's not that your advisor doesn't know the answers to your questions, it's that you don't know what questions to ask, and that is so true. So a good advisor is either going to educate you sufficiently so that you can ask competent questions so that they can be answered, or they're going to go through a more arduous process of asking the questions for you and informing you so that you can make appropriate choices. This takes time and effort. And yes, sometimes a lot of it can be reduced to a form that is provided to you at the beginning of a relationship. But keep in mind, filling out that form doesn't necessarily mean that it gets into the advisor's brain and information. And more importantly, it doesn't do all of the other things that are necessary in terms of educating you. So you see, as a result of that, you know now that nothing I'm going to say today should be construed as legal advice. It cannot constitute legal advice because we haven't met and I haven't talked to you about your specific circumstances. I'm going to provide you with general information. What I discuss may or may not apply to you, and they may or may not be appropriate solutions to you. Some of the solutions I'm going to talk to you about, there are actually better solutions for very specific groups of individuals. And if a better solution would apply to you, you certainly wouldn't want to accept one of the solutions we talk about here today. And you certainly wouldn't want to accept a solution that we talk about today that doesn't make any difference to you. So bottom line, this is not legal advice. Lastly, let me give you some guidance on operating the Zoom conference. At the bottom of your Zoom window, there should be two buttons that are important to you. One is the chat button, and you'll see the horizontal, the vertical, the up and down arrow pointing to the chat box. And that's the box that you're going to, if you have questions, so that I can answer questions at the end of the meeting. That's where you'll put those questions. Please write those in as we are discussing things. Okay, you don't have to wait to the very end to ask your questions. I will not take questions though until the very end. And as you all know, your video is disabled so other people can't see it, as is your audio. So whatever happens in your home, you don't need to worry about it influencing other people. You're only going to be able to hear me during this workshop, and that's for your convenience, all of your listening convenience. The other button is the button at the very bottom of the screen, and that is the button that you'll use to toggle between my face and the screen that you're watching, the one that says Zoom on it. I would encourage you to minimize my screen. Like I said, I'm the least important part of this workshop, and quite frankly, I wish they had a minimized screen on my bathroom mirror in the morning. That would make things a lot more pleasant when I'm getting ready. Bottom line is, you want to watch the workshop presentation, the slide presentation, and not watch the video of me, but it is available for you to go back and forth on if you want to. So let me go to the beginning slide that we're going to talk about, and that is this slide. And so we're going to talk about aging in place. We're going to talk about confinement and why it is so hard to avoid in today's system. We're going to talk about what is effective planning and how you can take action. This is our roadmap. So let's begin right at the basics. What is aging in place? As you can probably guess, the government has a great definition of aging in place, and this is it. It's the ability to live in one's own home and community safely, independently, and comfortably, regardless of age, income, or ability level. Now, that's a very short definition, but I think you would agree the brevity belies complexity, because it's your ability to live in your own independently, safely, and comfortably. Those things are important, but also it's regardless of some variables such as your income, your legal situation, your ability, or your age. So the definition of aging in place seems pretty simple, straightforward, but it is a little bit complicated. So why is aging in place important? Well, the biggest reason for me as a lawyer, whose most important job is to accomplish my client's goals and objectives, is because it is desired. Some studies show that as much as 97% of seniors, when asked, would prefer to be in their own home than in any other setting as they have health concerns and ultimately when they die. Next, studies show that happiness, satisfaction, and independence are all things that are best accomplished at home. You are more likely to be happy, you are more likely to be comfortable, you're more likely to feel satisfied with your outcomes, and you're more likely to have an experience of independence when you're in your own home. That probably makes perfect sense. It also as a result, gives positive health outcomes. Just because you're happier probably means that you're more likely to be well, but we're also going to talk about things other than the positive health outcomes that come naturally from being happy, satisfied, and independent. We're going to talk about the threats that institutional care provides. But there's no question that generally your home is going to be a better place for you to have positive health outcomes than an institution. Next, the next goal that most people have that is accomplished by aging in place is preventing filial responsibility. Filial responsibility is the obligation of your children to pay for your care and to provide for your support. Now, we're going to talk a little bit more about this in depth as we go through the workshop, but suffice it to say, the most common lament of seniors is that they do not want to be a burden on their children, particularly later in life. And if you want to avoid filial responsibility, if you want to avoid that burden, aging in place is generally the best way to accomplish that. If you age in an institution, well, that becomes more complicated, as we'll talk about. Lastly, most people want to avoid the inherent risk of institutional care, meaning the risks that you really can't avoid. There are some things about institutional care that are unavoidable and dangerous. And most people have a sense, especially after COVID, that institutional care is not some place that they really want their health dispensed if they can avoid it. So that's why aging in place is important. Well, if after all that is said, and most people agree that that's what they want, the question then arises, well, why isn't everybody aging in place? Why is there so many people in nursing homes? In fact, why is it that up until just a few years ago, it didn't matter which age cohort you studied, the number of people of each age going into institutions was going up? Why is it that long-term care insurance becomes almost impossible to finance? Because insurance companies keep going to the Department of Insurance saying more and more percentages of each age group are going into institutions. We're paying out more and more claims because the institution is being used more and more. That's confinement. That's a confinement risk. And we're going to talk about what causes confinement. And then, of course, we'll talk about how to avoid it. There are 4 things that lead to your confinement. The healthcare system, Medicare, the legal system, and we're going to talk mostly about guardianship in what causes avoidable and unnecessary institutional care. We're going to talk about your friends and family and how they can sometimes be a problem, whether they're intending to be or not, how they can actually cause your institutionalization. And lastly, we're going to talk about the financial part of it and poverty as a cause of institutionalization. So let's talk about the healthcare system first, because that's the one that most people are most concerned with, and it is the first inroad for most people to institutional care. Now, I don't really consider Medicare a healthcare system. I consider it a legal system. If you ever had to read the rules and regulations, or you had to fight about what they mean, you know that that's a legal system. But we'll call it a healthcare system because that's how most people understand it. But the last part of that characterization may be new to you, that it is a healthcare system that is more concerned with cost than it is with the quality of your care. That's a pretty big bombshell to just drop. And some people would say that sounds like it might be wrong. It's not. And it's not even a secret. I'm going to read to you quotes from a couple of years so that you know. But I want you to go back to the 1970s and just ask yourself, if you're aware, do you know how long people stayed in the hospital on Medicare in the 1970s? Well, the answer is kind of a trick question, because if you were answering that today, you'd probably say, well, it depends upon what your illness is and what your condition was and how you recovered. Well, back in the day, it didn't matter, because it was a simple answer, and it didn't matter what your situation was, because you stayed in the hospital long enough until you were able to go home. Simple. That's not what we have today. I think most of you would agree that the healthcare system that we had at that time is not the healthcare system that we have today. As a result of the high cost of hospital care, Medicare has, since the 1970s, reduced the amount of time that you can stay in a hospital in order to control costs. And that has caused what we call a system that gets seniors out of hospitals and into nursing homes quicker and sicker. This is a quote from the New York Times in June of 1985. Knowledgeable observers point to a serious assault upon the autonomy of older patients and the emergence of a dual standard of care for the elderly. Others are noting that older patients are being discharged quicker and sicker from hospitals. And of course, that was in 1985, and they were talking about changes that were being made to Medicare to do just those things. Here's a quote from the Senior Citizens League in January of 2015. It was actually in a part of an article that was titled, "Patients Are Sent Home Quicker and Sicker." Hospitalizations, they wrote, in length are rare. Patients who have surgery hooked up to IVs and EKG machines one day are sent home quicker and sicker than ever, with far more complex needs. Cuts under the 2010 Affordable Care Act and reductions imposed on Medicare due to the 2011 debt limit agreement, along with other changes made over the past decade, and that really should read the past few decades, are creating pressures to limit the duration of hospital stays. Medicare patients are discharged in very fragile health. Those with family and friends ready to step in and provide care are the lucky ones. That was 2015. Does anybody think that it's gotten any better? And of course it hasn't. It's only gotten worse. The result is that you are incentivized by Medicare to have less expensive nursing home care from the hospital. Now, most elderly patients are transferred to nursing homes when their Medicare benefit runs out. Using nursing homes instead of hospitals to complete elderly health care saves Medicare millions of dollars a day. Pushing the elderly out of hospitals into institutions is also heavily incentivized by the Medicare system. Following a 3-day hospitalization, you probably know these rules, Medicare pays the cost of nursing home care for 20 days. Medicare will pay the cost for days 21 to 100, but you must pay a copay. After 100 days, Medicare pays nothing for long-term care. So you are incentivized for at least 100 days under the Medicare system to use the nursing home as an alternative to the care that you get in the hospital. Now, I think you would all agree that if the quality of care that you got in a nursing home was the same quality of care that you get in a hospital, that no one's got a beef, no one's got a complaint. That works out well. Because after all, saving money and getting the same, that's a great deal. We do that all the time when we make decisions when we're buying. But the reality is they're not the same. One of the evidences of that are just in the myth of institutional rehab. You see, what we've now devised as an explanation for what happens when you leave the hospital is that you're going to be rehabilitated. In fact, many nursing homes have rehabilitation centers, rehabilitation units or clinics as part of their name. And yet studies show that 40% of seniors transferred for rehab never return home. There was no rehabilitation that was able to make it possible for them to go home. And that tells you to at least for a great number of people, rehabilitation in the nursing home is simply a myth. This is an article, by the way, from my blog, Aging in Place Planning and Elder Law. I'd commend you to take a look at that blog, and I would suggest that you subscribe to that blog so that you can keep up with developments in this area. But there's more evidence of the fact that nursing home care does not have the same quality. And the result of taking people from the hospital to the nursing home to round out their acute care means that less expensive skilled nursing care is creating a silent tragedy. This is the result of a study. 1 out of 3 seniors that are transferred from a hospital to a nursing home are injured or killed as a result of medical mistakes, causing them, at minimum, a transfer back to the hospital. Now, I would suggest that for most of you, this is brand new information, that you've never heard this information. Before we talk about the fact that you haven't heard it before, let's talk about what that study actually found. First of all, they found that of the people that were injured, almost 20%, 21% of those people were permanently harmed. An additional 1.5% suffered the most permanent harm possible, death, as a result of the mistakes that were made by nursing homes. 69% of these medical mistakes were preventable, and the results were, and I'll just go to the annual results, are that if we extrapolate the figures that they had, over 250,000 seniors are hurt every year because of mistakes made by nursing homes, and almost 20,000 are killed each year. And by the way, this study only considered seniors that were in a nursing home for 35 days or less. Why is that important? Remember that Medicare incentivizes 100 days of institutionalization. Now, I'm not going to kid you and tell you that extrapolating these numbers is easy or is even appropriate. I'm certainly not going to do it. It certainly is not true that the number is 3 times the numbers that we're looking at here, because 35 days is only 1/3 approximately of 100 days. But I think you'd all agree that the numbers that are demonstrated by this study are probably far greater, and would have been far greater, if the study had considered seniors that were in a nursing home 100 days or less. The longer the institution has control and custody and care of you, the more opportunities it has to make mistakes, and the more likely it is that those numbers will increase. The reason that I say that this is silent is because you've probably never heard of this. I remind folks that we spent days, months talking about a measles epidemic that took 1 life. And wasn't even a life in the United States, but for days it was on our newspapers and on our televisions. COVID-19 has been a daily thing, but this is something that you haven't heard about. You may think that this study is the result of some university or small group of researchers who actually dug into some very innocuous data, and that it's not something that's well known to the industry or to the government. But you'd be wrong. The study that I'm talking about and the statistics that I'm reporting to you are actually from the Department of Health and Human Services Office of Inspector General, in a study conducted in 2014 regarding adverse events in skilled nursing facilities, and they titled it "The National Incidence Among Medicare Beneficiaries." This isn't secret. It's just not something that's discussed, because after all, the concern here was cost of care. And how do we keep people from being re-hospitalized from the nursing home, okay? It's not just the quality of your care. The result of what happens in these institutions is what I call a vicious circle from which there is often no escape. You go to an institution for rehabilitation, you take a certain care risk that often means that you're injured, often permanently. And a permanent injury makes it more likely that you're going to need permanent care. And as a result, what should have been a short period of care necessary for you to recuperate becomes instead a long-term or even permanent need. This explains why over time we see more and more seniors, even at lower age groups at 65, 66, 67, more seniors are finding themselves in institutions permanently, is because of the reality and the outcomes that we find in nursing care. That's the institutional healthcare system. Temporary need often becomes permanent because of other risks that are inherent to a nursing home. Now, I would suggest that mistakes are inherent in any institution, but there are also risks that are inherent in a nursing home that don't depend upon there being mistakes. A good example is fractures. Nursing home residents are twice as likely to suffer fractures than the same people that suffer the same falls when they fall at home. Nursing homes habitually violate federal standards year after year. It is hard to get nursing homes to follow the standards of quality of care that are necessary. Skilled nursing facility workers often are the least likely workers to have vaccinations that are recommended. We're fighting about that right now because of COVID. COPD patients discharged to nursing homes have twice the risk of death than those who simply go home. Hepatitis infection risk in nursing homes was up 50% in the year that I wrote this particular article. Infection risk across the board increases. Most terminal dementia patients in nursing homes are given pointless and potentially dangerous drugs. And of course, there's security risks inherent to long-term institutional care. I've written a complete series of articles on the security risks that are inherent in nursing homes. Maybe you have been paying attention. Most people don't see these articles or these news clippings, but there is actually a serial killer that is being tried in Texas who went from institution to institution, killing residents. Assaults and murders and other situations that occur in nursing homes often are not reported. And so people don't know that this is even a risk. I remind folks that just like with hospitals, nursing homes have the same types of medications that are available in hospitals. Every hospital has a security guard or a security team. Many of them have police officers. I know something about that because my daughter works as a police officer at a major hospital system. And they have security not only for their staff but for their patients and the visitors to the patients. Most nursing homes don't even have a security guard. CNN did an amazing investigative report entitled America's Most Vulnerable Seniors Raped and Sexually Abused in Nursing Homes. Most people didn't even hear that study or that report. It didn't come to the nation's attention until it was actually reported on the National Wire Service that a woman who was in a nursing home in Arizona had a baby. She was impregnated as a result of a rape, and the nursing home did not even know until she went into labor that she was pregnant. That's when most people first learn that there are security risks in these nursing homes. Resident-on-resident violence often goes underreported. Institutional care means that you suffer transport risks. It doesn't even begin when you enter the nursing home. The risk begins when they move you from the hospital to the nursing home. We've had crazy incidents. One incident where a senior was dropped off on the side of a road because GPS for the transport service said there was an institution there. Even though if they would have gotten out, they would have looked, there was no institution. We had another man who died fortunately, that man did not die. They were able to, when he didn't show up at the institution he was supposed to, they went out on a search for him and they found him. There was a man who died as a result of being let off at the front of an institution, but because he had dementia and he wandered, he never got through the front doors, apparently. And as a result, he wandered out into I think a bog, and he perished. These are incidents that occur, and most folks aren't even aware that they occur with at all, let alone with some degree of frequency. One of the issues that comes about that is an inherent risk is the way we now treat your care. And this is because of a new controversial sign-off rule. Let me explain what the sign-off rule does and what it means and what it really tells you about our Medicare healthcare system. Before the sign-off rule, if you were a senior and you were transported from a hospital to a nursing home and you felt that the nursing home didn't have a handle on your care, you weren't getting better, and you felt that they just didn't have a good handle on your treatment, you could call a family, call an ambulance, you could go back to the hospital, and the hospital would admit you and take a look at you and make a determination as to what was happening. If a family member wanted to take you, a spouse wanted to take you, if the nursing home was taking care of you and they felt we don't have a handle on this guy or this woman, and so what we're going to do is transfer them back to the hospital, they could just do it. Well, Because of that, and because of the fact that rehospitalizations cost Medicare money, Medicare instituted what was a new controversial sign-off rule. And what it says is that if you're that senior and you don't think the nursing home has you, you can't go back to the hospital on your own. If you're the spouse or a family member of the senior and you think, you can't simply take them back to the hospital. If the nursing home, the institution the federal government has entrusted your care to, believes that you should be transferred back to the hospital, they can't do it alone. They've actually got to get a check off or a sign off by a doctor who has to come and take a look at your situation and make a determination that transfer back to the hospital is reasonable. I want you to think about that for a second, because it's not just that the federal system doesn't trust you or trust your spouse or trust your loved ones. It doesn't even trust the institution that it has entrusted your care to. That's a pretty cynical rule from a person in the eyes of a person who looks at this dispassionately for the benefit of my clients. But that's the reason that this and all of these other reasons, and many more, by the way, are reasons that temporary need often becomes permanent because of the inherent risks of institutional care. If you think that your family can navigate the nursing homes in your area by picking the best one, you probably are wrong. Federal nursing home ratings are misleading. This is an article from the New York Times in March of 2021, so that's this year. It was entitled "Maggots, Rape, and Yet 5 Stars: How U.S. Ratings of Nursing Homes Misled the Public." Now, this was published, obviously, in the wake of the pandemic. The headline had a subtitle that indicted the nursing home industry by saying nursing homes have manipulated the influential star system in ways that have masked deep problems and left them unprepared for COVID-19. The role of the government is from benign neglect to incompetence and complicity is also discussed in that New York Times article. The bottom line is that the rating system and the information that often is provided to families to make decisions as to which institution is best and which institution is not so good are oftentimes is completely incorrect. And by the way, the same studies show that most of the decisions with regard to institutional care, whether they're made by a referring institution like a hospital or they're made by your family, are based upon proximity to something, proximity to a hospital, proximity to your home, proximity to your kids' homes, proximity to something. And the reality is those same studies show that that's rarely the best basis upon which to make a decision between competing institutions. Ohio has great nursing homes is a common sentiment. And why should you not think that? Because we have a generally high quality of healthcare in the state of Ohio. So that must mean that institutional long-term care is of generally high quality. And that makes sense and it seems logical, but it's just not true. In June of 2019, I published an article that entitled "Ohio Receives Near Failing Grade on Nursing Home Report." The Families for Better Care, which publishes a state-by-state nursing home report card based not just upon federal data, but also data from ombudsmen and data from families and their own surveys and lawsuits and violations of rules and regulations, whether they are settled or not. They do a ranking and they determined that Ohio was ranked 40th in the United States. Now, if we get time and you really want to know the answer, if you ask me the question in your chat box, why is it that Ohio can have such great health care and have such horrid nursing home care, I can kind of give you what I think is the explanation, but we'll do that at the end of the workshop. The bottom line is that it's pretty clear that the Medicare system has implemented a cost savings program that increases your risk when you go to the hospital. Because when your Medicare benefit runs out, you're increasingly put into an institution, which puts your health care at risk. So I would like to think being a member of the legal system, that the legal system, as it often does, has a solution to your problem, and that the lawyers are going to come to your rescue and prevent you from being institutionalized in a place where your health is not going to be properly taken care of. But the reality is exactly the opposite. The legal system is often a risk. First of all, let's talk about guardianship and institutionalization. Now, all of you probably know what guardianship is. It's the legal system's a way to appoint a person to make decisions for you when you're not able to make decisions for yourself. Guardianship is a legal procedure that occurs when you can't make decisions, so you have somebody that can do so. Guardianship and institutionalization actually work synergistically, meaning one supports the other. Guardianship often means institutionalization. Guardians prefer institutional care to having you take care of yourself at home or having your family members take care of you. Institutions often refer residents for guardianship. In fact, this year I wrote an article, not this year, last year I wrote an article about how hospitals and nursing homes were actually getting into the guardianship business. They were actually setting up groups that would be and provide guardians for people that needed them. I can't think of anything that would make me less comfortable than my hospital or my nursing home or my assisted living facility also being my guardian. How does my guardian protect me from the institution that they're basically employed by? But institutions often refer residents for guardianship. And by the way, institutions can unilaterally keep you against your will only through court-appointed guardianship. And that is going to surprise you, because most of you probably believe you can't be kept anywhere against your will. But yes, institutions can and routinely do keep seniors against their will. Now, let's be candid. There are many good reasons an institution might keep a senior against his or her will. If they are, for example, a danger to themselves or a danger to others, then the institution is well justified in keeping someone against their will. But there are also powerful institutional forces that have nothing to do with your best interest or the best interest of others that compel nursing homes to keep seniors against their will. Consider this. To a nursing home, you are a new elderly patient, recently hospitalized. They're inherently unfamiliar with your mental, physical, and emotional condition. Discharging you simply because you say, I don't want to be here, I want to go home, I want my daughter or my son to take care of me or my spouse to take care of me. Discharging you may be the $1 million mistake. Imagine that they release you and you get out in your car and you drive through a schoolyard full of children. You have become their liability. Now, a lot of people think that, well, they're going to let you go. They're just going to make you sign a release that is a release against medical advice. But I actually have to tell you as a lawyer, these are meaningless in this type of situation. And so they're meaningless to protect you by giving you an avenue out of the institution. Why? Because if you're not competent or capable of understanding the release has no effect in protecting the institution from the liability that befalls them. Makes sense, doesn't it? In other words, if they are the people that think that you're competent and capable, and you get into that automobile and you demonstrate pretty clearly that you're not competent and capable of taking care of yourself or taking care of your others, that release is going to do absolutely nothing for them, which is why increasingly institutions simply don't let you out. An institution protecting itself from liability is just one example where powerful institutional forces resist your simple desire to go home. We also have a problem with what I call ageism or confirmation bias. Frustration, for example, with how a nursing home is treating you and its resistance in carrying out your wishes. For example, the resistance in letting you go home, or the resistance in providing you the food that you want, or resistance in providing you the care that you want, or resistance in providing you visitation with loved ones that you want, can cause you to become impatient, angry, uncooperative, or confrontational. Agitation is a symptom of dementia. It presents as irritability, restlessness, sleeplessness, and verbal or physical aggression. Can you see how unfortunate, unexpected, and even tragic outcomes occur when a healthcare system that is preoccupied with cost and institutional concerns, meaning concerns other than yours, force people to make decisions quickly with incomplete and potentially inaccurate information? You can be diagnosed as being suffering from dementia simply because you're having a rational reaction to what you're experiencing in the nursing home. The healthcare system often works against seniors who are wishing only to exercise their rights and have the best quality care that they think is in their best interest. That is ageism and confirmation bias. Now, guardianship is not just a synergy to nursing home care. Guardianship is its own risk. It actually risks everything. I'm going to read to you a few quotes. I'm going to just try to read the red parts, but these are quotes from a hearing on guardianship over the elderly, security provided or freedoms denied. The first paragraph is actually the statement of Larry Craig, who was the ranking senator of that committee at the conclusion of the hearings. He said guardianships are judicial interventions allowing for the management of an elderly's adult personal affairs and property. When used correctly, in very extreme cases, guardianship can be an important tool. At the same time, guardianship can divest an elderly person of all of his or her rights and freedoms that we consider important. When full guardianship is imposed, the elderly no longer have rights to get married, vote in elections, enter into contracts, make medical decisions, manage finances, or buy and sell property. They cannot even make decisions where they live. Guardianship can drain an elder's estate, result in protracted legal proceedings, and substitute the judgment of a total stranger for those of the senior and their family. Guardianship can even result in institutional rather than alternative care and separate elders from their families and actually terminate marriage. Yes, terminate marriage. Why is that important and why is that significant? Well, I would think if you're married, that you understand that your spouse is your best protection in the world against third parties. I know I'm married and that's how I see my spouse. No one can take advantage of me so long as my wife is standing between me and them. And that's probably how you see your spouse. But nursing homes have devised a way to make that irrelevant, because if you're in a nursing home and your spouse is belligerent or difficult, hard to work with, simply trying to get the best quality care possible for you, but in their minds, just a distraction, they can simply, once a guardianship is established, terminate the marriage. A guardian can exercise your rights to terminate a marriage just by asserting that there's irreconcilable differences. It has happened numerous times in this country, and it is almost always with tragic results to the senior. The next statement is from an attorney by the name of Michael Kutzen, and he said guardianship statutes generally recite lofty principles of honoring the wishes of the senior and their family and offer a myriad of supposed protections. In practice, however, once a guardianship proceeding is brought against someone, most of these most guardianships they're approved, and machinery begins that often presumes that a guardian is required and runs roughshod over the wishes of the senior and his or her family. This is particularly true where the proceeding is commenced by a hospital or a nursing home, or family members live in another state, or where the senior has significant assets. The last quote is from a woman by the name of Dr. Armstrong. She is a nurse. She's a doctor and she was a nurse and she's a senior advocate, and she warned that neither the public nor the legal system fully recognize the powerful forces that conspire to strip seniors of their rights and liberties. She said that these are court battles fought over money, power, and control, and the elderly lose them 94% of the time, even when they contest them, often in proceedings that take only 4 minutes. Now, I have to tell you, I have been involved in guardianship battles, and I've not known for these proceedings to take only minutes when there is a battle. They take only minutes when there is no battle, but oftentimes there is no battle because you don't have anybody fighting for you. They don't necessarily notify your family members. The bottom line is guardianship abuse, which means using guardianship when it's inappropriate, and guardians that then abuse you, take your assets, confine you against your will when it's unnecessary, keep you from family. Guardianship abuse and abusive guardianships have a system, according to the National Association to Stop Guardianship Abuse. And that is It starts with stolen lives, stolen fortunes, physical abuse, and financial abuse, and it's always conducted in the same way. You isolate the senior, you medicate the senior, and then you drain the estate. Isolate, medicate, drain the estate. That's from the National Association to Stop Guardianship Abuse, which, by the way, is only one of about 5 national organizations that are specifically designed to fight for the rights of seniors and their families in guardianship court. Now, you might think, given this rather obvious problem, that everyone would agree that there should be a solution to it and that Congress would come to the rescue. In fact, the hearing that I'm quoting from was actually from February of 2003. But we've had hearings on this same issue in 1977, 1987, 89, 2003, 2011, 2007, 2018. We had one in 2020 that doesn't appear on their list. And these always have titles, just like the title of guardianship over the elderly, security provided, or freedoms denied, that indicate how concerning this issue is. For example, one of them was abuse of power, exploitation of older Americans by guardians and others they trust. That was the 2018 hearing. But no legislation from Congress ever occurs because this is a state probate issue. And in fact, when the GAO was tasked by Congress, by the Senate, to provide them information about what happens within these specific probate courts, almost no probate courts provided them information. And as a result, they had to come back with a very thin report, which is unusual. GAO reports are usually really thick, compilations of data and tables and informations. But it was a pretty thin report indicating that for the most part, they couldn't get information because they didn't, as a federal agency, have jurisdiction. And by the way, this is the same thing in the state of Ohio. Ohio guardianship laws leave seniors vulnerable to abuse was an article by the Ohio News Service that was published in February of 2019. That doesn't mean that Ohio is not trying to solve the problem. Specifically in specific probate courts, we have an enlightened group of judges that have, quite frankly, beyond the laws, the protections that are provided by the statutes, they have in their own courts provided protections. That doesn't mean that the system always works perfectly, but at least in some counties in the state of Ohio, you have judges that are advocates for guardianship reform and have implemented procedures that protect them, that protect seniors more than what otherwise would exist. That doesn't mean that bad things don't happen. Bottom line is Ohio is a troubled system when it comes to guardianship, just like almost every state guardianship system is. If you want to know what counties to avoid and which counties are not so problematic, I can certainly talk to you about those when you have a specific need. But right now, just know that guardianship is a problem even in the state of Ohio. And there's other ways that the legal system avoids the right of seniors to age in place, both in terms of Medicare, both in terms of enforcing the laws in the probate court and providing cover for the probate court. Part of it is the way that the legal system has almost a myopic attention on your demise. In other words, most estate planning lawyers, what they really do is they ask you, what is your stuff? And who do you want it to go to? And their planning is really limited to that and maybe providing healthcare decision makers or financial decision makers if you are ill and you can't make your own decisions. But for the most part, it's really what happens with your stuff at your demise. It's not this type of lifetime planning to empower you to enact your own decisions, okay? So let's talk about how friends and family, your social safety net, can sometimes not be a net for you at all. There are 2 basic groups that I'm going to talk about just to give you a sense of what the problem is. First is the well-intentioned but misinformed family member. Guardianship and institutionalization decisions are often recommended by legal, financial, medical, and government agents without consideration of all the factors or risks. Most of the people that work in the system think nursing home care is dandy. They won't tell you what the risks are. And so as a result, bad things happen. Consider the story of Esther Barone. Her story, by the way, is available on my YouTube channel, my firm's YouTube channel, but it's also available at the National Association to Stop Guardianship Abuse website, which is www.nasga.com. She actually tells you her story. I want you to remind yourself, if you watch that video, that when she's telling you her story, she's legally incompetent. She's not able to purchase gum at a retail store because she legally is a child, unable to contract, unable to make decisions. How this all happened was Esther's daughter was advised to apply for guardianship as a precaution while she was still in the hospital. The result, because Esther didn't have an estate plan in place, Esther didn't have anything that said what happened if she became ill. And as a result, the lawyer had the daughter go and apply for guardianship. The result was that her mother was placed in an assisted living facility before she fully recovered by a court-appointed guardian, and the guardian placed her home for sale. How did this happen? Well, the lawyer, first of all, didn't tell Esther's daughter about the risk of guardianship, didn't tell Esther's daughter that somebody other than Esther's daughter and the lawyer were going to be appointed as a guardian, because as it so happens, Esther lived in a different state than her daughter did, New Jersey and New York, and as a result, her daughter wasn't even qualified by law to be a guardian. So because no one discussed with her the risks, she thought she was doing what was in Esther's best interest. And what she basically did was opened up the chicken house to the wolf, and the wolf got in and took control of everything. By the time anything was said and done, Esther was well enough to ask what the heck happened. She'd already been placed in an institution against her will, and she was unable to check on her assets. And as a result, they were sold. Now, aside from the well-intentioned but hopelessly misinformed and misguided family members, there are also the hostile and ill-intentioned family members. Family members and friends may desire to control your assets. They may try to steal your wealth or property. They may want to make visitation more convenient. I've had 2 instances in the last 10 years where a senior was basically kidnapped by a family member, taken to a different state other than the state of Ohio, and either placed in one instance in an institution or kept with the son in the home against the will of other people back home that were taking care of that person, because they didn't want to have to come and visit all the time. It was just more convenient for them. They can want to prevent you from consorting with others. They may not like your choice of mate. They may not like your choice of spouse. They may not like your choice of friends. They may want to force you to provide property or services to them. They may want to live in your home, for example, against your will. They may want to prevent you from complaining about their deeds. If they've stolen from you. If you are too vocal, sometimes they'll even tell you, if you say anything to anyone else about what happened, I'm going to put you in a nursing home. And they may disagree with your lifestyle choice, your choice of residence, your intended beneficiaries of your estate plan. Why are you giving all your assets to your other children? I'm the one who has the need. I'm the one that has taken care of you. I'm the one here talking to you right now. You're going to give your estate to me, or bad things happen. This happens. Guardianship and institutionalization as either a threat or a tactic in disarming a senior are effective and used, and they can keep a senior from making and implementing lifetime decisions. Friends and family, unfortunately, are not always a safety net. I'll also mention that we're having an increasing problem, especially after COVID, with estrangement, with abandonment. And I just published an article on abandonment, and we've always known that it was a problem that some children abandon parents, and some parents don't disclose to their trusted advisors, like their wonderful lawyers, who ask them that there is an abandonment, that there is a impairment of that relationship. And increasingly, it's becoming a problem, because when decision makers are necessary and they're appointed by documents, the family member simply says, I have no idea what you're talking about. I haven't talked to that parent in 10 years. Don't talk to me again. And they hang up the phone. It's a pretty bad culture we live in right now. One of the articles that I wrote about, I think 2 years ago, was about what was a pre-COVID, not too uncommon practice of family members taking their demented loved ones that they no longer could take care of in their own homes, putting them on planes with a one-way ticket to metropolitan areas where they would hope that somebody would just pick them up and take care of them. I'm not kidding. This problem was so bad that in, I believe it was Seattle, they actually built a hospital to care for the orphaned seniors that has simply been dropped off in Seattle and Portland. It is just heartbreaking what some people will do to folks that you would think they would have some love or affection for. Bottom line is, friends and family could be a social safety net, but it can also be a danger. One of the ways, by the way, you can make sure your friends and family aren't a danger is by educating them. So that's one of the reasons that some of you I know are attending this particular presentation, is because you've been invited to attend by your loved one. And I commend you for trying to understand what their goals are and their objectives are and what the threats are, because that makes you a better capable decision maker for them. The next thing that we're going to talk about is poverty. Now, poverty is the one thing that should be the only absolute, other than just profound chronic physical disability, should be the only thing that makes it necessary for a person to always choose institutional care, because that's what Medicaid does. Medicaid sits as a safety net for people that have no ability to take care of themselves, no alternative to institutional care, and it provides the cost of care through basically a social welfare benefit. Okay. The problem is that poverty is not just something that happens as a result of the natural course of planning. Oftentimes we're finding that Medicaid planning is the cause of poverty. You may have been to a workshop where somebody talked to you about the dreaded nursing home and taking all of your assets. And as a result, you need to protect yourself. And so what often happens is, just like this slide depicts, a senior is counseled to give all of their money to their children, where if they do it 5 years in advance and they do it properly using an irrevocable trust, a trust that the senior can't control and a trust that the senior can't change, that they can then save their assets from long-term care spend down. And let me tell you, I'm going to be candid with you, full disclosure, I do Medicaid planning and I do create these kinds of trusts. But I also educate my clients regarding the alternatives and the risks of these trusts, which if you attend these workshops, you never hear. I have talked to numerous clients who have actually implemented these plans and asked me to undo them once they realize the risks. So first of all, let me go back, because Medicaid planning is planned indigence. It's basically making a senior incapable of taking care of themselves. It has to be done within 5 years of a need. You know that there's a 5-year look back. But in order to accomplish it, you can't own the asset, you can't control the asset, you can't use the asset for support, and you generally can't be the trustee of the trust. There are some exceptions in some states, but the reality is, what these do is they take assets, and because they remove them from the assets that are available to meet your needs and take care of you, that's how you have to structure that trust in order to qualify for Medicaid. Because if the money can be used by your family for your support, guess what? It can be used by the state for your support. But what these do is they can effectively protect those assets from nursing home spend down. But what most people aren't told is that nursing home spend down isn't always the worst thing that happens, because there are ways that we can transfer assets using certain rules. There are certain exempt transfers. A good example that I use a lot when I'm doing aging in place planning is having a family member, a grandchild, a child, somebody that's sometimes a family friend, where we've got an agreement to use them as an intermediary, where we can have somebody live with the senior. It has to be a child, where we'll use the senior, have the person live with the senior for a period of 2 years. If there is a child that provides care for the senior for a period of 2 years, we can transfer that home to that child, and it doesn't cause any kind of problem with Medicaid. You can also convert assets to income. If you've got a husband and a wife, for example, one of the concerns is, well, what if I spend down all my assets? My spouse isn't going to have enough to take care of herself or himself for the rest of his life. We can convert assets to income. A spouse that is in the home, not in the nursing home, can have $1 million worth of income a month, And the nursing home spouse that's bound in a nursing home can qualify for Medicaid. Most people don't know that. So if we do some planning in advance, we can take care of it. We can pay for family care. If we do it correctly, meaning we're not just making gifts that are untethered to the care needs of a person, we can actually pay the family to incentivize them to provide care in the home, and also mean that there is not a nursing home spend down. There are also VA benefits available. Most people don't know that VA benefits are available even if your disability, if you were a veteran and you served during a time of war, you are entitled to a pension, even if your disability has nothing to do with your service. And that pension can then pay for the cost of care in your home. We can use qualifying income trusts. If your income is too high, but you don't have assets and you think that you're not going to be able to get Medicaid, we can use a qualifying income trust. And of course, one of the things that I use in my planning with seniors when they have real serious health problems is hospice, because hospice can keep you at home. Hospice is paid for by Medicare. So you don't have to be indigent, you don't have to be poor, you don't have to worry about somebody taking your home or your car or your spouse's money or your children's inheritance. Hospice can take care of you when you most need it, and that's all within the rules of Medicare. The disadvantages of traditional Medicaid planning are it's costly. Most of these trusts usually run north of $5,000. You can't use money for your support. That's a bad one, because since you can't use money for your support, it increases the risk of institutional care. If you're in hospital and you are moved to a nursing home, or they threaten to move you to a nursing home, and you say, I want to go home, and they say, well, can you take care of yourself? And you say, no, because I have no money to take care of myself, because I've taken all my money and given it to my children, and that's locked up in a trust, which, by the way, specifically says it can't be used for your support. Well, you've just increased your risk of institutional care. If the money was in your bank account, you could go to your home and pay on a monthly basis for caregivers to give you the rehabilitation that you might need, or even if it's a permanent need, to pay for what you need at home. You can't change the plan when you need or want to. These are all built on the backs of irrevocable trusts. And while oftentimes lawyers will tell you, well, it's not really irrevocable, that's not the right answer. It is irrevocable by its terms. There may be ways to change a trust that isn't working properly, but these usually come at huge expenses. And so you have to go into them thinking that you can't change them if you need to. And that can create some weird situations, because what happens if the wrong children become the people that are taking care of you and you want to change that? You can lose control or use of your assets. It may not work. The biggest problem with irrevocability is that the laws change. We used to use, for example, life estates to avoid Medicaid spend down. Simply transfer your property to your child, retaining the life estate, and we didn't have to worry about your home being sold. Medicaid got wind of that. The state of Ohio changed the law. Those no longer work. If the laws change, now you're stuck in a system that you've planned for that may not be able to change with you. Here's the worst problem with them. Most of my clients don't even understand this when I first talk to them about the Medicaid plans that they've put in place. And that is that they almost always create a problem with filial responsibility. Let me explain what that means. We are a filial responsibility in the state of Ohio, meaning that there is actually a statute that makes it a crime for a child to not take care of an indigent parent, okay? That law, although it exists, is not enforced in the realm of Medicaid or Medicare. We just don't use it for that. That's true in most states. In fact, it was true up until a few years ago in the state immediately to our east, the state of Pennsylvania. Well, the state of Pennsylvania, though, did what CMS told all the states that they should consider, which is to start enforcing their filial responsibility laws that are on the books, because that would make children then responsible for the care of their seniors. Remember that most seniors don't want to be a burden on their children. Well, in Pennsylvania, it's actually the law that you have to be a burden on your children. Your children are responsible to reimburse the state of Pennsylvania for any Medicaid benefit that's paid to them. Now, by the way, that doesn't mean that they can get back money you gave them. If you gave them no money, but your kids have their own, the state of Pennsylvania can knock on their door and sorry, I shouldn't have knocked on my desk, can get their money back. That's the law in the state of Pennsylvania. It's created huge problems. That's called filial responsibility. The state of Ohio can snap their fingers at any time and enact filial responsibility as part of their Medicaid program, at which point your children will be responsible for to reimburse the state for your long-term institutional care, which means that if you have one of these trusts, what's going to happen with that trust when you give all the money to your kids at the time of your death, which is how most of these estate plans are drafted? Well, it's only going to create a nice big bundle of money that the state's going to get back from you. So you've accomplished nothing other than put yourself at greater risk of all of the health outcomes that are endemic in these institutional care alternatives, because you didn't stay at home. You paid more for your care ultimately than you would have if you would have just managed your own care in your own situation, in your own system over time. And you've accomplished nothing if the state of Ohio goes there. And by the way, remember, if you have one of those plans right now, if you have an irrevocable Medicaid trust, they don't call them Medicaid trust for reasons that you can read about in my blog, but if you have one of those trusts, you may be locked into a system that is going to make those assets available immediately upon your passing to the state to get paid back for Medicaid that you've applied for, which means you haven't accomplished anything. Aging in place versus Medicaid planning generally works like this. If you have a Medicaid plan, most lawyers that do Medicaid planning put everything they can in the Medicaid trust, because after all, why not? You've already made the decision to do it, so protect as much as you can, which means you have little or nothing left to take care of you in an alternative form of care outside of a nursing home, because you just don't have the resources. Aging in place as a perfect plan, only doing aging in place planning, would give absolutely no credence to Medicaid, and so you would put nothing protected by the Medicaid plan, and that can be what a lot of people do. In fact, I would say that probably statistically, most of my clients do that. A lot of my clients, though, do a balance. I do Medicaid planning for folks, but I'm, like I said, I'm honest with them. I recommend Medicaid planning anytime I have a farmer or a business person that has a family business, because the issue there is not inheritance. It's that at age 50 or 60 years old, you may be telling your children that they have to find a new job if the business is liquidated in order to pay for long-term care. Farmers don't want their adult children having to leave the farm. And so there are reasons that, besides just, rank, treatment of the assets, graven treatment of the assets for the benefit of their children, there are reasons that they may want to do Medicaid planning, but you can always balance these. You can take assets that you can protect, but still keep assets that are necessary to provide for alternatives to institutional care or to fund long-term care insurance if you want to balance a plan. So just know that those alternatives are there, but understand that the legal system, meaning lawyers, are often a challenge to your aging in place, because they make it impossible for you to age in place by planning that they advise is in your best interest without telling you the full story, okay? So those are your risks of confinement. So how do we solve the problem? What is effective planning? And that begins with, what is aging in place planning? Aging in place planning is a comprehensive plan designed to implement a strategy of aging in place, protecting your independence and you from the risk of unnecessary, avoidable institutionalization through supported decision-making. We haven't talked about supported decision-making. Some of you may know that term because it is used frequently in the area of disabled children or special needs children, because oftentimes we are providing supported decision-making to those who have some capacity to make their own decisions. In this area, though, an effective plan to age in place means supported decision-making is going to cross legal, medical, financial, and social arrangements so that your decision-making is implemented. Supported decision-making means basically that you make your decisions now while you can. You put your decisions in writing and communicating them to the people that you then empower to implement your decisions. While you are able to make your own decisions, they they stand beside you and behind you in making your decisions and in implementing your decisions. But if it ever becomes necessary, they can then step in your stead, step in front of you, and protect you from all of these institutions by implementing your decisions. That's what supported decision making is. It obviously is a transition or a spectrum of different situations that may occur over time, and how they orient is going to depend upon your specific situation. But the bottom line is that if you don't implement this as a strategy, it's not going to work for you when the time is needed. So to have an effective plan to age in place, you need to have a legal plan. You need to have legal decisions and documents. You need to have medical and health care taken care of, your medical decisions and documents, financial decisions, your access to money and availability. And also, you need to think about your own social safety net, the people, places, and things like your home and it being suitable for you. This is all part of the plan. So let's talk about these. We'll spend a little bit of time on the legal part, and then we'll go to the medical part. The most important thing to know is that despite what you may be told by lawyers or what you may be told by old books regarding estate planning, a power of attorney simply doesn't protect you. This is the actual testimony from Diane Armstrong. She's somebody who you heard before. She was Dr. Diane Armstrong, who was a former nurse, and she's a senior advocate. She wrote that when an elderly individual is brought into court and forced to prove his or her competence, we soon see the system does not work. We have a system rife with court-sanctioned elder abuse. Why? Judges override protections that have been put in place by the codes. It happens every day. They disregard durable powers of attorney, the single most important document each of us can create to determine our care should we become incapacitated. We have seen the healthcare proxy overturned in a case called Orshansky, where a judge simply ignored a list of pre-selected surrogate decision makers. She says and concludes the current system does not work. Simply providing a power of attorney, which is what most lawyers will tell you, you got this. If you got a power of attorney, you don't need to worry about there being a guardian. That doesn't do it. That's not sufficient. Attorney Robert Aldridge testified at length before that same hearing about what seniors needed to do, and he indicated the court will rely only upon a correct and powerful lifetime planning trust and a power of attorney as an alternative to guardianship. In other words, it's something more than just the power of attorney. And by the way, it's not every trust that does it. Some trusts won't protect you. Many trusts discourage court-appointed guardianship, which is sometimes called living probate, only by creating a surrogate decision maker. You've got a decision maker appointed, so they won't need to go to the probate court. That protects you from well-intentioned and well-advised family members seeking guardianship. But most trusts don't protect you from third parties seeking guardianship. They don't protect you from hostile family members. And most importantly, they don't even protect you from ill-advised family members that want to protect you, well-intentioned family members. In other words, the power of attorney does not do enough, and a trust that is not oriented properly may not do enough. In fact, the wrong trust can actually hurt you. One example would be those irrevocable trusts we talked about, which impoverish you, but also many trusts, even if they're not an irrevocable trust, can still become a powerful weapon for public guardians because they often require that in the event of disability, that the trustee actually pay to the guardian all the trust assets. This is something I've been amazed at since I first started doing trust planning in the state of Ohio. If you look at my history, I originally started in the state of Missouri, where I lived because I lived in St. Louis, where I went to law school at Washington University School of Law. And I practiced for 5 years there. And when I came back to the state of Ohio, I was shocked to find that almost every trust has a provision that says that if you become disabled and a court-appointed guardian is appointed, that the trustee has to turn over assets over to the guardian. The combination of easing control and disarming a possible legal challenge to the guardian may actually encourage the appointment of a guardian. In other words, look at it this way. If you're deprived of assets, if all the assets are in a way that you cannot control, meaning the guardian controls those assets or they're controlled by an irrevocable trust that can't be used to protect you, How do you protect your rights? You can't go hire a lawyer if you can't pay them. There are very few lawyers in this realm that will take on the representation of a senior when there are assets that are unavailable. They just won't do it. Most trusts are legally vulnerable to guardians. The Ohio Trust Code, I'll talk about the Uniform Trust Code later if we get a chance, but the Ohio Trust Code is very clear. It says that a guardian of the estate of the settlor, or if no guardian of the estate has been appointed, a guardian of the person of the settlor can exercise the settlor's powers with regard to a trust. If you have a typical revocable trust, you know that you were told that the best thing about the trust is that you can always get the assets out if you want them. You can always change the trust if you want. And you probably weren't told that unless you do something more than that, your guardian also has that power. I've actually used this to invade trusts of wards, meaning somebody that there is a guardian for, when I represent the guardian and I want to control the assets for the guardian, and I don't want the trust to control the assets. A lot of times the reason that we're appointing a guardian is because a trustee has abandoned or abdicated the responsibility to provide for that senior. And I can simply file a single motion and oftentimes without a hearing, get control of the entire trust estate. That's great when I'm representing those clients. That's a scary, scary proposition for the rest of my clients. And so I've devised my trust so that guardians can't control those assets. By making those assets unavailable, the first thing we do is disincentivize a guardian, because then they can't get paid, because they're only paid by the assets as a percentage of the assets that they actually control and manage. But we also keep assets available so that we can fight and enforce the client's rights. That is an important part of the planning. But as you can probably guess, to suggest that even the right trust and the right power of attorney is going to solve the problem, it's not just any power of attorney, it's not just any trust, and you got to have something more. You got to have a plan. You must have a document separate from your trust, will, and power of attorney that does a couple of things. It's got to define the legal standard for incompetence. It has to appoint your physician by name to determine your competency or lack of competency. It's got to empower your trustee to act if you become incapacitated. It needs to restore your authority in the event that you recover, and in the event that you recover from whatever condition it is, and it needs to operate without involvement of a probate court. Now, we call that document in our estate plans a competency clause, okay? But other lawyers in different states call it something a little bit different, but by and large, they are very rare. You very rarely see these documents in a traditional estate plan. It's just not something that most lawyers are doing. You also need a powerful lifetime planning trust, and it has to do some specific things. It needs to implement and enforce your lifetime wishes and appointments. It's got to state explicitly your desire to age in place, to remain at home, if possible, despite a worsening medical condition or impairment. You need to require a trustee to use the least institutional care setting possible, regardless of cost. You need to authorize the trustee to refuse to pay a third-party court-appointed guardian. You need to protect the trust assets from control by a third-party guardian. You need to authorize advanced planning for government benefits eligibility. And if you're married, you need to resolve conflicts between spouses when one or both become impaired. Now listen, none of this is stuff you need to think about or you have to think about. But if you don't think about it, it's going to be a problem when the time comes that you got to think about it. If you're not able to make decisions for yourself, or if somebody claims you're not able to make decisions for yourself, or you don't have somebody that can stand in your stead to make the decisions that you want them to make, or if you've got somebody you've appointed and they have no clue what to do, the reality is you may not get the result that you want. Having a powerful lifetime planning trust is going to make it more likely that you're going to get the result that you intend. You also need a strong, durable power of attorney that also implements your lifetime planning decisions and appointments, encourages the least institutional setting possible regardless of cost, authorize advanced planning for government benefits eligibility, and nominates a guardian in the event that one is necessary. You always limit it first to a guardianship of the person so that the assets are always controlled by the trust. Now, I mentioned the possible regardless of cost, that you use the least institutional care setting possible regardless of cost. We're going to talk about why you need that. You can regardless of what anybody tells you. You can legally protect yourself from unnecessary institutional care. You need to state your wishes. More estate plans state your wishes regarding disposition of your bodily remains than state a preference for non-institutional care. You need to adopt proper duties. Aging in place duties are what we mean by the duty to use least institutional care setting possible regardless of cost. The reason? Because a duty of the law for any fiduciary, a power of attorney, a trustee, an executor, is the duty to conserve assets. It is a paramount fundamental duty. Do you understand how Medicare works against this duty? In other words, when the choice is a dangerous institutional care alternative that is free or safe, better, more independent, more preferred care in your home that may cost you money, if you're not making the decision, if the decision is being made by your guardian, is made by your power of attorney, is made by your trustee, they may, if you don't orient these duties correctly, be duty bound to put you in the nursing home. Do you understand now why Medicare in part incentivizes your institutional care for 100 days? It disarms most families from being able to undo the system of care that Medicare has decided is the cheapest. That is the reality. You then need to empower your agents. Few estate plans empower the family to seek and prefer non-institutional care and do other things like have private care agreements. You need to educate your agents. You need to advise your agents of alternatives to institutional care, that they're available and they're preferred, or you can do what a lot of people do these days, which is just use bumper stickers. I'm not kidding. The legal, healthcare, and government benefit system have let down so many people that some senior and disabled advocacy groups are actually passing out bumper stickers. No kidding. They simply say, don't put me in a nursing home. I can't think of anything that is more sad than the fact that we've relegated our good planning to a bumper sticker. So we've got the legal taken care of, at least we've discussed it, but now we need to talk about medical decisions and documents. And again, you can legally protect yourself from unnecessary institutional care in your medical decision-making. Again, you need to state your wishes, inform your healthcare professionals, family, and or your agents. Your healthcare power of attorney is a good place for you to include, if you haven't included it in your trust or in your general durable power of attorney, your decisions with regard to non-institutional care. You need to update these documents. You should have a durable power of attorney, a living will, a HIPAA release, and an advanced declaration for dementia. Most clients that I talk to that are new don't have a HIPAA release, don't have an advanced declaration for dementia, and many of them have old statutory or non-statutory powers of attorney and living wills. You need to update your documents as these documents become more modern and as they become more effective in implementing aging in place decisions. You need to safeguard and ensure their availability. Ensure that your wishes, information, and documents are safe and accessible when needed. You may want to consider a program called Legal Vault. We will send you information regarding Legal Vault so you can evaluate it. We're actually going to give you an inducement if you want to use it. But basically what it does is it means that your family is never going to have to search for where your power of attorney for healthcare or your living will is. It will be included in the same system that the healthcare system uses in getting medical information for you, so that once they identify who you are, they can simply have those documents fax-backed, which is how they use a system called fax-back, those documents directly to your nurse's station or to your doctor or to your hospital. There was a great article on my blog that the New York Times wrote in a study and an investigation about how the number of times that people have living wills and durable powers of attorney, but when healthcare decision-making is needed, no one can find the document. You need to review your Medicare choices annually. New programs are added every year. Traditional Medicare and a supplement may have worked best for you at retirement, and they certainly were traditionally what I always advised, but an Advantage plan may make more sense as you age, and they may make more sense given what your specific circumstances are. You should see a Medicare specialist who understands aging in place, and if you don't know one, we can advise you to go see one. We know who you can go to. You need to supplement, if possible, if you need to supplement, if possible or affordable, your health care with additional insurance. Long-term care insurance is an example. You need to look at short-term disability, long-term disability, catastrophic illness, home health care, preventative health care plans or wellness plans. All of these things can help you stay in your own home. Some of them you can simply capture with other healthcare decisions, like a Medicare Advantage plan. Oftentimes we'll have wellness plans and have some preventative health care, and also provide for home health care insurance or home health care alternatives because it's cheaper for them. So they incentivize it, even though Medicare doesn't. But you can also go out and purchase these. So getting to the right financial person or insurance person can help. You should also embrace technology. Telemedicine, wearables, security systems, medicine, vending machines, passive fall detection, voice-activated smart homes. Technology can empower you to stay at home. And let me tell you, just to give you an example of how things have changed. About 2 years before COVID, I was sitting in a hospital at Loma Linda, California with my brother who had suffered a heart attack. And while he was recuperating and I was visiting with him, I was typing an article on my blog about telemedicine. And the experts at the time said telemedicine is never going to scale for the boomers. It was never going to be available to help keep seniors in their home, even though it would be a big boon to aging in place, because there wasn't enough investment in it. And then COVID came, and guess what? Telemedicine is here, as is a lot of the other technologies that seemed pie in the sky only a few years ago. I tell people, you no longer have to wear a bracelet. You no longer have to wear something around your neck. You can have passive fall detection in your home with a security system that uses the same motion detectors that would detect an intruder. They just are programmed then to detect changes in elevation. And that way you don't have to feel like you have to wear something that's uncomfortable. And more importantly, if you don't happen to have it on you, you still have the same protection that a bracelet or a pendant would provide to you automatically. You don't even need to be able to. So for example, if you lose consciousness, you don't have to be able to press a button. You actually get the same benefit as a result of technology. So take a look at, embrace technology, particularly as it provides solutions to you. Financial, you can financially protect yourself from unnecessary institutional care. So here's some things that I think everyone should do. First of all, evaluate your risk. Unexpected loss of assets can impair your financial ability to pay for long-term care and for alternatives to institutional care. I tell my clients to focus on guaranteed lifetime income, since alternatives to institutional care usually require monthly outlays, whether it's short-term or long-term. If you can pay the bill on a monthly basis comfortably, then you can stay in your home, and it really doesn't matter how chronic or how impaired your condition is, except in the most extreme cases. You should also reconsider long-term care insurance. Believe me, if you look at my blog, you can tell that I am not a fan of long-term care insurance or the long-term care insurance industry. But as the market contracts, newer innovative solutions are being adopted. So don't give up. Review them every several years, even if you've rejected them before. And if you do get long-term care insurance in Ohio, make sure it's a partnership plan. That gives you an equal amount of Medicaid protection for every dollar of insurance that's used in keeping you at home if it pays for home health care, or paying for institutional care if ultimately you need institutional care. You should evaluate your health care coverage. Your Medicare choices and Medicare supplemental insurance choices can help or harm your ability to age in place. See a specialist. Reconsider the leverage of life insurance. Life insurance can replace income lost upon the death of a spouse, and or it can leverage assets for future use with less risk. See a financial planner for your options. I can always talk through options with you. Obviously, I'm not a financial planner. I'm not an insurance agent. I can't sell these products or these alternatives to you, but I certainly can, in the event that you have someone that doesn't understand what's needed, I can educate you to what to ask them so that they can go search them out. If they can't search them out, then you can always find a different agent or a different advisor. You should also consider long-term care when you're making financial choices. Most people don't even know that when they purchased an annuity or they purchased life insurance, or sometimes when they've purchased an investment that is non-traditional, meaning not just a mutual fund, that some of these investments actually have long-term care planning opportunities that are available. such as through riders or waivers or supplemental benefits. You need to consider these carefully when accepting or rejecting a strategy, investment opportunity, a contract, or policy when you're making decisions. I always tell my clients that the best thing to do is that, for example, if you're purchasing an annuity or you're purchasing a particular investment strategy, is ask your financial advisor, is there a way to get the same thing that this contract or this opportunity provides me, but also fund home health care if I need it, or incentivize increases in income if I'm disabled? Because all of those things are potentially available to you, and they may make the difference in your ability to stay at home if you need it. So consider your long-term care when you're making any decisions with regard to your plan, with regard to your situation. Lastly, with regard to the people, places, and things, I'm not, as I said at the top, I'm not going to talk about how to make your home livable, but that's part of it. You can create a social safety net and environment protecting you from unnecessary institutional care. First of all, select your agents carefully. You should have trust and confidence that the people that you choose will act for you, making decisions you would make. Avoid the impaired and recovering, and don't let relationship trump honesty, integrity, and business acumen. Don't dismiss siblings and friends. Some of the biggest mistakes I see made are people who tell me that they talked to a previous lawyer when they were making their plan, and the person that they trust the most is a younger brother or sister, and the attorney told them, well, they're your generation, you can't use them as a decision maker. Well, worst case scenario is that you need the decision maker tomorrow, not in 10 or 15 years. That actually becomes a better alternative than the worst case scenario. Choose the best person first. The circumstances will dictate whether they can serve. And of course, as they age or as they pass away tragically, if you have successors, your plan will automatically provide the safety net that you need. But don't dismiss the people that are best simply because of their age. Build a social safety net. Churches, synagogues, fraternal organizations, friends, charities, and support groups can help you build what you may not be blessed to have. If you don't have a group of children that you have trust and confidence in to take care of you, or if they're cravenly motivated to protecting your assets at the expense of your physical security, putting you in a nursing home earlier so that they can spend down their assets for their benefit, or helping themselves to your assets, then you can protect yourself. I will tell you that that two religious organizations have made this almost a war cry of sorts. They probably hate that word. With regard to identifying vulnerable seniors. The two are the Free Will Baptists, who have a Free Will Baptist Foundation that actually educates congregations and churches regarding some of these aging in place issues and taking care of vulnerable seniors, and the Mennonites. The Mennonites have embraced the fact that many seniors in the modern age, even though their modern age is a different definition than what our modern age is, that many seniors don't have the safety net that they used to have. And as a result, they're reaching out and taking care of them. You can build a social safety net if you don't have a natural one. You should consider a trust protector. The position's title speaks for itself. It's actually somebody that would protect you against somebody you have appointed who is no longer acting in your best interest. And that person can be a non-fiduciary. That person can be a professional, such as an insurance agent, a lawyer. They can be an accountant. They can be your tax preparer. They can be somebody that doesn't have an interest in your estate, but can simply fire a trustee who's not doing the job in taking care of you that they're supposed to take. You want to maintain contact and connection. People, their circumstances, and their abilities change over time. You don't want to be in a situation when you need somebody that you weren't even aware that they couldn't make decisions for you, or they weren't available to make decisions for you. So you want to maintain contact and connection. This is obviously a good thing to do aside from your aging in place plan, but your aging in place plan means that you've got to be aggressive about this. You want to evaluate and reevaluate. Don't wed yourself to any selection. Don't wed yourself to any plan. Don't wed yourself to any group, any person. Make sure that you're constantly evaluating whether it's going to work or it's not going to work. I remind you, there is no limit to succession. You can choose several alternatives. I have some clients that have 10 different people appointed in succession, one person after another person. That happens a lot when people choose from their own generation because they don't yet have trust and confidence in a younger generation, or because they just don't have younger generations that they ever will have trust and confidence in. You can choose as many alternatives if you want. If your lawyer or your planner, whoever that person is, financial agent, insurance agent, ever tells you to limit that, they're not doing what's in your best interest. Use as many as you can possibly think of. Usually, I'm going to ask my clients, now that we've nominated those 3, 4, 5, is there anyone else? And if they can't nominate somebody else, I will tell them, continue to think about it. Continue to think about who among your friends, your families, your associates, the people in your groups and in your community. Find people that you would have trust and confidence in. And if you identify those folks, give me a call. We can add them. It doesn't take anything. It doesn't cost very much if it costs anything at all. In most cases, it's not going to cost anything. And we can then have them taken care of. And of course, modify your home and your automobile. Environmental changes can empower you to age in place. We're not going to talk about all the different things you can do to do that, because quite frankly, this is the one place in aging in place where there is a plethora of information, thanks to the building trades and industries and the realtors. They're doing a great job of letting folks know that their decisions with regard to their home can impact their ability to age in place. But the only caution I will give to you is don't believe that that is the only decision that you need to make, that once you've chosen the right home, that it's all done. Because as you know from everything we've talked about in the workshop, that's clearly not true. Aging in place planning is basically developing an effective strategy that takes into account your legal plan, usually through an aging in place lifetime planning trust, a healthcare plan, a Medicare Advantage choice, long-term care insurance, disability, hospice care, a financial plan, resolving risk, focusing on guaranteed income, making sure that money is liquid, making sure that you have the appropriate insurances that might supplement your ability to stay at home when you're making other financial decisions, and of course, a social plan that involves supported decision-making, meaning putting all of this together in a plan that's in writing, educating your family regarding what your decisions are, and then supporting them in making the decisions that you want them to make in your best interest. That is supported decision-making. And that comprises what is effective planning. So, in order for you to do that, we're going to help you make a connection. You've got the knowledge, but we're going to help you make that knowledge make action so that you can have an effective plan, so that you can solve the confinement risk and implement an aging in place planning. For attending this program, we will, if you retain us, waive a consultation fee. That will be free. We will reduce the cost of an aging in place trust package. We will provide you with 1 year of Legal Vault for free so that you can see how it works and you can see if you're comfortable with it. Legal Vault, as I mentioned, is that program that makes especially your healthcare power of attorney and your living will available to doctors immediately when it's needed. And it is an important part of providing you safety and security. You can also add to your Legal Vault 2 additional things. You can have your legal documents protected from loss, theft, destruction by circumstance, by having them vaulted. You can also have a separate password vault. The legal documents, for example, you can make available to me and my staff if we want to gain access to it to change things or to add additional documents to it, but you don't have to. The password vault, you would basically give no one authority to invade until you've become disabled and or you've passed away. You don't have to use any parts of those. The biggest part of it is the healthcare part, but they do provide ancillary services. This provides you, if you attended this program, basically almost a $2,000 savings, and we'll do that for 30 days. Now, here's the thing. One of the reasons people ask me, well, gosh, usually when they do this, they want you to make a decision right now, and they want you to implement the plan within a certain amount of time. I don't do that. let me be candid about this. You know what good legal advice entails because I educated you about that at the beginning of this program. It's not just because I want to incentivize you not to procrastinate and because I want to help you get to me as quickly as possible. The reality is by attending this program, you make my representation of you easier because you've already been educated regarding these topics. So I'm really just passing the cost savings on to you. If in the 30 days you say you're interested, but you're not ready to go forward, just let us know, because I will give you this cost savings since you've gone through this program. But it's nice to know that you're considering it. It's nice to know that you are serious about your planning. And then of course, the other thing we can do is during that time, we can support you by keeping you advised of changes, keeping you advised of changes in our practice, changes in the law. And that way you're not stunned when you come back to us in 6 months and say, I want to implement this, and find out that something is a little bit different than what you thought because you just attended this presentation. By keeping you within our system, you know, subscribing to my blog and getting newsletters and that kind of thing, you're going to keep up to date on these issues. And of course, that makes it easier for me to represent you. That makes it easier for you to make decisions that we're going to talk about in that representation to everybody's best interest.